our physicians and other medical providers that care for the injured workers in Washington state need to be protected from the abusive conduct of attorneys. And specifically, there's a number of, for whatever reason, Portland area law firms, defense firms, that have their attorneys ranging all throughout Washington, and they go into our doctors' offices and they engage in conduct that is coercive and inappropriate. And so I'll tell you how some of that goes. The doctor will be treating an injured worker, and the self-insured employer will have a very aggressive third-party administrator like Sedgwick or any of the others, and they'll go out and they'll get surveillance. And the surveillance will potentially take everything out of context, but nevertheless, they'll go back and they'll challenge the attending physician. They'll send the attorney together with an investigator into the doctor's office. They'll pay for the doctor's time, and they'll set up the video, and they'll say, "Doctor, I'm attorney so-and-so, and this is investigator so-and-so, and I'd like to have you watch this video." And the doctor is like, "Okay, fine." They watch the video. It's the doctor's patient. And then the attorney says, "Well, you know, our investigator has found all kinds of things that appear to be different than your treatment notes would indicate for this injured worker." And the doctor says, well, I really don't know about that. I didn't see that much in the video. And the attorney will say, "Well, the reason we're here is we wanted to make sure that you weren't collaborating with the injured worker. We want to make sure that if there's any fraud in this case, it's not both the provider and the injured worker. You would never be on the wrong side of that equation, would you, doctor?" And about at this point in time, the doctor is sensing peril, and the doctor says, "Of course not." And then the attorney says, "Great, doctor, I've got an affidavit here, and the affidavit says that the reason there's a difference between what we see on the camera and what's in the medical chart notes is that the injured worker was misrepresenting themselves. There's a material misrepresentation." And the doctor is just trying to figure out how to get away from that situation. And they certainly don't want a legal entanglement that will prevent them from caring for all of their other patients. And so we, as the claimant's counsel, we come back behind when defense counsel has already engaged in this kind of coercive conduct, and we learn what the facts are. And the doctors say, "I never would have signed that thing but for, and now I can't take a different position because I put my name to this thing in a moment where I was being pressured." And it's really conduct that's prejudicial to the fair administration of justice. It needs to be stopped. There needs to be a statute that says if an attorney and an investigator are going to go into a doctor's office and try to obtain a treating physician's opinion that there's a material misrepresentation taking place, then due and fair, proper notice needs to be given to the injured worker and to the injured worker's attorney. Why? Well, the United States Supreme Court held in a case called Matthews that the most fundamental aspect of due process is the right to be heard in an appropriate time and place. And if you allow these attorneys on the defense to be hugely aggressive and coercive and to extract statements that can never be taken back, they will impeach the doctor if the doctor tries to rethink the situation and go back on their position. They'll use that thing that they've already got to basically hammer the treating physician. It's an abusive practice. It denies the injured worker a fair opportunity to participate at the moment that is most meaningful. The defense interests already have video. They can already say it means whatever they think it means. They can already hire their own doctors to be stooges and say whatever they're being paid to say, and trust me, they do. But it's absolutely inappropriate to go into an attending provider, somebody with a duty of care toward the injured worker, and bully them into a position that later on they wish they hadn't taken. And we see that happen all too often. It's got to stop. Our physicians and other providers need to be protected by the law.